Good afternoon. My name is Linda Waters, and I am the Acting Director, Deputy Director for the Office of Small and Disadvantaged Business Utilization. We are here for another acquisition training, and I would like to introduce Ken Dodds. He is the Director for the Small Business Office of Policy Planning and Liaison. Ken, welcome.
Thank you very much, Linda. I'm going to talk today about the regulations that we're working on at SBA, and we've had a lot of work lately. The Congress has been very busy in the National Defense Authorization Acts of 2013, 2014, 2015, and they're even working on one in 16. And in each of these kind of legislations, they have some small business provisions lately. So I'm going to go over some of the more important ones that we're working on right now to try to let you know what's coming and what's going to be changing and what's the status of the rules that we're working on at SBA. I'm going to start with one from the National Defense Authorization Act of 2013. And this one changes the way that we calculate the limitations on subcontracting. As you know, we have limitations when there's a set-aside contract. We want the small business to do some of that work so that the intended beneficiaries are actually benefiting from the programs that we have for these types of businesses. Right now, if you're working on a service-disabled veteran-owned or a hub zone set-aside, you're allowed to use, as a prime contractor, you can use subcontractors to help you meet the performance requirements that apply to that contract. If you're working on an 8A small business or women-owned set-aside, you cannot. And so as you know, services is 50% of the cost incurred, must be incurred by the prime, and construction has a 15% requirement. Specialty trade has 25%, manufacturing has a 50% cost of manufacturing, and then of course there's a non-manufacturer rule. So in this legislation, Congress did two things. They told us that we want similarly situated subcontractors to be able to team together with the prime to help meet the performance requirements. They also want us to change the way we calculate things, because in the past it's been difficult to figure out what the cost incurred were, because there's a lot of things that are included, there are things that are excluded, there's a lot of accounting that goes into it, and they wanted to simplify it to an amount paid. So it's basically a limitation on not costs, but amounts you're paying. So it's a limitation on how much you can actually subcontract out. I mentioned, I've noted at the bottom there was a case called Sealift out of GAO. And in that case, someone protested that the small business wouldn't be able to meet the limitations on subcontracting. And in a footnote, GAO noted that this new law had passed, and they said that even if the small business couldn't meet the limitations, the subcontractor for this small business was a small business as well, and so under this law they would have been able to meet the limitations. There was no evidence that I could find in that case that this was put into the solicitation or part of the rules, because right now the actual FAR rule is the same as that we've had for a long time. It's 50% of the cost incurred, and then on a small business set aside, it has to be the small business prime that meets that. But because of this case, agencies may have tried to move out on this legislation before we do our rules. And the way it usually works is when small business legislation is passed, SBA does a proposed rule. It's usually open for 60 days for comment. We go through the comments, and then we do a final rule. Once we've issued our final rule, we send a case to the FAR Council, and the FAR Council starts a business case to actually change the FAR and to change the FAR clauses and get those into the contracts and solicitations. So that's the process that usually happens when it comes to new rules. So with respect to this legislation, we issued a proposed rule in December of 2014. The comment period has closed. I think we received over 200 comments. And some of the things we wanted to address were what happens when an agency is buying multiple things together. That's a common occurrence where an agency is buying both supplies or services in an acquisition. So one of the things we tried to propose was we think it should just be based on what the NAICS code is. So you're supposed to pick the NAICS code that represents the principal purpose of your acquisition. And so if the principal purpose of your acquisition is services, but there are some supplies that are not the principal purpose, that would be considered a service contract, and the service performance requirements would apply. And likewise, if it's a supply contract and the most value of the contract is supplies, we're going to consider that to be a supply contract, And the supply rules will apply, not services, because many businesses are focused on one area as a small business. You might be a service company, you're not also a manufacturer, or if you're a manufacturer, you're not also a service company. So we want one rule to apply to these types of contracts. We proposed, in order to use these subcontractors as part of your team, we proposed that there should be a written agreement, kind of identifying who the subs are and what percentage of the work they're going to do to help the prime meet that 50% requirement. And we did propose that if we're going to do this written agreement, whether the firms actually do what they were forecasted to do isn't material. What is material is that collectively, the prime and the subs on this contract actually meet the limitations on subcontracting that have been imposed. And we wanted to make sure that there wasn't a pass-through. The whole point of the limitations on subcontracting is we want the prime to do some of the work and not just pass it on to a large business. If we're going to allow a subcontractor to help meet that requirement, we want to only count the work that the sub is doing towards that. We don't want to allow them to turn around and then pass through it to a large business, thereby getting around the rules in the first place. While we were changing the rules around teaming based on this legislation, we also took a look at our rules on joint venturing, because as you know, there's two kinds of teams. There's a joint venture and there's prime sub. When there's a joint venture, both parties are liable for performance, and they're jointly and severally liable to perform the contract. If it's a prime sub relationship, the prime is responsible for performance and the subs report to the prime. So right now we have rules that generally say that if two firms joint venture to perform a contract, collectively they have to meet the size standard. That means we put together their revenues or their employees to see if they meet the size standard. But we do have rules that allow joint ventures where just each entity itself has to be small, and collectively they can exceed the size standard as long as each is small. And we have those special exemptions for really large contracts, for bundled contracts. And so what we did in this proposed rule is we decided to say we're going to propose that the general rule be for all acquisitions that is, as long as each member of the joint venture is a small business, we're going to count that to be a small business. And so we wanted to get comments on that. Now, we did note that excessive joint venturing between firms can result in affiliation. Now, some of the other things we tried to clarify here were recertification. Many years ago, we did a rule on recertification. As you know, the general rule was we determine your size at the time of your offer for the contract. So that means even if you grow to be large during contract performance, it's still considered to be a small business award. But we ran into some trouble when we started getting these long-term contracts, okay? Contracts for 20 years, contracts that never ended. So we proposed a recertification rule that basically provides that if there's a novation, acquisition, or merger, you have to recertify. And then for long-term contracts, which are longer than 5 years, we want you to recertify prior to the 6th year and then prior to each option thereafter. One of the issues that came up was, well, what happens when there's an offer and prior to award there's an acquisition or a merger? And we think that the rule should be and should have been based on common sense that you still have to recertify at that point. If you had been awarded the contract, you would have had to recertify. So the fact that you haven't been awarded the contract yet shouldn't give the agency the ability to keep credit for a small business award if you're not really a small business anymore. So we propose to address that. We also wanted in this rule to address some of the affiliation rules that we know about from our Office of Hearings and Appeals case law. At SBA, we do size protest decisions. When an apparent successful offeror is a small business, the unsuccessful offerors can file a size protest challenging the status of the intended awardee. And so we do that in the area offices, and then those decisions can be appealed to our Office of Hearings and Appeals at SBA. And so what we have is we have cases from OHA saying here's what the rule is, but those rules aren't actually in our rules written. So what we're trying to do here is to put some of the writing onto into the rules. So, for example, there's a rebuttable presumption of affiliation among family members. That's husband, wife, father, daughter, siblings. There's also a rebuttable presumption that firms that derive 70% of their revenue from another firm are economically dependent on those firms and therefore affiliated. Now, these are rebuttable presumptions, and we went out specifically to get comments on what, these rules. We wrote them out and we got comments on those, so we'll be looking at those when we do the final rule. One of the other areas we tried to address in this rule focuses on the non-manufacturer rule. Our rules aren't real clear in that area. The non-manufacturer rule is based on a statute that says, just because you're not the manufacturer of the product doesn't mean you can't be a small business and submit an offer on a supply contract as long as you supply the product of a small business. And there's also, in addition to that, a way for SBA to waive the requirement to supply the product of a small business if SBA determines that there are no small business manufacturers of that item. And there's ways we do that. We do a class waiver where we do it through the Federal Register and it applies until it's revoked. And we also do individual contract waivers where on each contract the CO can come to us and say, there are no small business manufacturers, I'd like to get a waiver. That allows you to buy the product of a large business basically from a small business on a set-aside contract. One of the things we tried to clarify here is that these rules, these limitations on subcontracting and the non-manufacturer rule do not apply to contracts below $150,000 if they're small business set-asides. They do apply to other set-asides like 8A, HubZone, and so forth, but specifically for small business set-asides, they do not apply. And this is consistent with the FAR right now. The FAR instructs you when you're doing a small business set-aside to include the limitations on subcontracting clause in the contract, except for contracts valued below $150,000. So we propose to clarify that based on the statute. We also wanted to address software and how that applies with the non-manufacturer rule. Software is complicated because if we hire you to create software through a contract, that's a service. But on the other hand, a lot of people in industry and government buy software off the shelf. They treat it like a commodity, as a supply. And so our rules were never really clear on how we treat software with respect to whether it's a supply or service contract. And so we went out for public comment on what should the rules be around software. When will we issue a waiver? Will we issue it if it's just software off the shelf? Or what happens if it's software off the shelf plus services, ongoing services from a large business? Should that qualify? Because you can waive the non-manufacturer rule for supply contracts if there's no supplier, but there's no such thing for services. Services still have to be performed by small businesses. So we wanted to get some clarification around, try to provide some clarification around how those rules should interact. We also wanted to make it clear that everybody needs to be aware of what's going on. When you submit an offer on a supply contract, if there's no waiver in place, you're basically telling the government that if it's set aside, you're telling the government that you made that product or that you're supplying the product of a small business. Now, the only way you don't have to do that is if there's a waiver. But if there's no rule that requires you to be notified of that waiver, you might be in jeopardy. So what we wanted to make clear is we want the contracting officer to request these waivers prior to issuing the solicitation. And then if we issue a waiver, or if there is a class waiver, we want you to put that in the solicitation so that all the offerors know what the rules of the game are. Do they have to manufacture it? Do they have to supply the product of a small business? Or can they supply the product of any size business because there's a waiver in place? So I think that'll help clarify some of the supply issues that we've had in the past. So that's the rule that came out in December, specifically on limitations on subcontracting, joint venturing, and the non-manufacturer rule. In the same National Defense Authorization Act of 2013, they gave us authority to create a mentor Protégé program for all small businesses, identical to the 8A mentor Protégé program, except to the extent necessary. So a little bit of background, SBA back in 1998 or so created a mentor Protégé program for 8A participants. The program allows 8A participants to joint venture with a mentor and be treated as small for any government contract. And the mentor in those cases can be any size business. It can be a large business. There's also a lot of other assistance that the mentor is supposed to provide the protege, and there's rules around how you qualify to be a mentor and protege. In the Jobs Act of 2010, Congress gave us authority to create a similar program for HUBZone, women-owned, and service-disabled veteran-owned companies. While we were working on that rule, the NDAA came out and said, we want you have authority to create one for all small businesses. And so that's a big change for SBA, because if you think about it, there's maybe 5,000 8A participants and maybe 500 mentor-protege relationships. But small businesses, there are probably hundreds of thousands of small businesses that at any one time registered in SAM that want to do business with the federal government. So it covers all those businesses, and it's going to be a lot bigger program. Now, they also said in this legislation, we want you to review the existing mentor-protege programs out there to see whether they should continue or whether there should just be one under SBA. Now, it excluded DOD, but a lot of agencies without any legislation have created their own mentor-protege programs, and it appears Congress was concerned about what those rules were. You know, is there potential affiliation there? You know, because our rules don't exempt affiliation among other protege programs. They really only address 8A mentor-protege. So that's, once we issue final rules on this mentor-protege program, one of the things we have to do is within 1 year of that, decide whether existing mentor-protege programs of agencies will continue. So in order to implement this legislation, we went out with a proposed rule in February of 2015. The comment period has closed. I think we received 180 comments on this particular proposed rule. And so we're in the process of drafting the final rule. Some of the things we tried to address were, we want the joint venture to be in writing. We wanted to address the issue of whether the joint venture can be populated or not. Our rules right now say a joint venture can be populated, which means the joint venture actually employs the employees, or it can be unpopulated, which means the joint venture doesn't have employees and the employees of the joint venture are actually in the two entities that are joint venturing together. But in this rule, we propose that to get rid of the populated joint venture, because how do we know, the whole point of the mentor-protege joint venturing is we want the protege to benefit. We want their employees to work on this and manage the process. If they're the employees of the joint venture, it's hard to tell whether they're still the employees of the 8A or not. Legally and technically, they're actually the employee of the joint venture if it's populated. And so we want to make sure that the 8A firm or the protege firm, in this case, is actually performing some of the work. We also asked the question of, should joint ventures have to be separate legal entities? There's different ways to joint venture. You can form an LLC and be a joint venture, but you can also just agree to come together, two companies, to perform work. And that happens all the time in the commercial world. But it gets very complicated for government because, for example, we have all these systems, and the systems rely on a DUNS number. And so if you're giving a DUNS number of a company that's not the actual joint venture, it can become challenging. And we've had a lot of issues about, how do I award to a joint venture that isn't a separate legal entity? So we asked the question of, should we just require it, just so we can all keep track of whether this is a joint venture or whether this is an independent business. We also proposed to address the HUBZone program joint venturing rules. Right now in the HUBZone program, in order to joint venture, both entities have to be HUBZone. And we've proposed to make HUBZone joint venturing just like other programs, which allow HUBZone and a small business to joint venture together, for example. As long as the HUBZone's in control of that joint venture, they could submit an offer as a HUBZone on a HUBZone set aside. We also proposed, if we're going to allow these joint ventures, should we have some kind of requirement that they certify that they're going to meet the performance requirements, and then report to the contracting officer how they've met them? Because it's very important not just that the joint venture together meet the limitations on subcontracting, but we want to make sure the protege is doing the percentage of the work that we've identified, which I think is around 40%. We also, because of the size of this potential program, we asked the question, how are we going to deal with the applications? Should we have an open season? Should we limit it to certain types of small businesses at first? Because we don't want to open up the doors. We were not given money to actually implement this legislation, to stand it up. So we need people and resources so that we can review the mentor-protege relationship, What about joint ventures? Do we have to review those? And then we have to monitor the performance to make sure that the protege is actually benefiting from this program. So there's a lot of work that goes into running a mentor protege program. How are we going to handle that if hundreds of thousands of small businesses are interested in it? And we also wanted to clarify that under the legislation that was passed, mentors must be for profit. Right now in the 8A program, you can be for profit or nonprofit, but the legislation says for profit. We also, wanted to get comments on how many proteges should you be able to have. How many. Now, under the 8A program, a protege must be small for the primary industry. And you have to be half the size standard, no 8A contract, developmental stage. What are the standards going to be for proteges as we go forward? Can a protege have more than one mentor? Right now, I think it's allowed in the 8A program. How many mentors should they be able to have? We're going to have to obviously verify whether the protege is in fact the small business or the type of small business that they're claiming to be. We propose that the agreement be in writing, that it be approved by SBA, and that it clearly identify all the assistance that the mentor is going to provide the protege. This is very, very similar to what the 8A program rules say right now. We also propose that this relationship lasts up to 3 years with 1 3-year extension. Now, that's 8A right now. I believe it's approved and it goes until such time as it's not approved. But as you know, a small business can be small forever. A hub zone can be a hub zone firm forever. In the 8A program, you eventually graduate. And so, we think maybe the rules have to be a little different here because the whole point of this is to build up the development of the protege. At some point, you've had enough, and you can't be a protege forever. Basically, is what we're trying to make sure that the assistance is not just for the large business to take advantage of this program, but to build up the protege so they can perform contracts. We also, said that we will have an annual report that you'll have to submit, and then based on that, if we don't believe the mentor is providing the protege with the required assistance, we may not approve continuation of that relationship. We wanted to make clear that, even if we've approved a joint venture, the size of a joint venture can still be protested. We still have the process where an unsuccessful offeror can point out something saying that even though SBA approved the joint venture, there's a reason for this firm not to be considered a small business. We also went out to try to address changes in the primary industry classification. This is important for entity-owned firms like ANCs and Indian tribe-owned firms because they have special rules that exempt them from affiliation, so they can have multiple firms in the 8A program. But they're not supposed to be in the same industry. They should only have one firm in a particular industry, and the other firm should be in different industries. And so there's a rule that says, they can't own a firm in the same industry within the previous 2 years. And there's been some issues where firms come in under one NAICS code, but they end up doing work in another NAICS code that happens to be a NAICS code that a sister company is also performing in. So we wanted to get input on, should we be able to change this, and what should the procedures be when we change someone's primary industry classification? We also talked about voluntary suspension, in a disaster or when there's a shutdown. When you're in the 8A program, your time may be ending during that time, and you may lose out on opportunities to get contracts before you graduate. So we proposed a way for 8A firms to be able to kind of suspend their program term until the disaster is over, like something like Katrina, or until a shutdown's over if there's a shutdown. And then we also wanted to address more about entity-owned concerns. We proposed some benefits reporting where they kind of tell us what are the benefits that they're providing to their their ANCs or their Indian tribes. Because they have all these special exemptions and from affiliation and so forth, what is that doing? What are the results of those special benefits? And then we did try to clarify that for the reverse auctions, that the rule of 2 applies, the requirement to do a COC applies, and I think there's some case law on that. What we've been seeing with reverse auctions is that agencies are turning them over to entity, a company, and then they're running it like they're the contracting officer, and they're excluding small businesses from bidding, for example, and they don't have the right to do that. They're finding small businesses non-responsible, basically, without referring them to a COC, and that's not proper. And again, the company is an agent for the government. The rule still applies. So if for example, 2 or more small businesses are going to submit an offer, that should be set aside under the rule of 2. So that's Minna Protégé, and that rule, as I said, has been finalized and it's closed. Now, there's a new proposed rule that just came out on the 6th of this month. The comment period goes till December 7th. And basically this has to do with credit for lower tier subcontracting. You know, right now, if you're a prime contractor and your contract's of a certain size, you have to have a small business subcontracting plan and you report on your progress towards that. The rules right now are set up so that you actually report only at the first tier level. So there may be many tiers below where there's small business activity, but we're setting your goals and you're reporting only at that first tier level. Under a new section 614 of the NDAA of 2014, Congress directed us to set it up so that the subcontracting plan goals and the reporting is done at every tier. You know, so basically, if you're a large prime at the very top, we're going to hopefully set your goals. The idea is your goals will be set not just for the first tier of small business activity, but small business activity below those tiers. And then you somehow, we haven't figured out how that's going to be reported, but the idea is that those activities at below will count toward your goals that have been set that way. It doesn't relieve lower tier subcontractors from having their own individual subcontracting plan. And we want to make clear that we're only reporting the dollars once. So even if it's reported to a prime or to a sub and then another sub and then another sub, the dollars for purposes of the agency, when we report on how an agency does towards their subcontracting goals, these dollars are only going to be reported once. So this is a difference. This is a change in how the prime reports on a subcontracting plan, but it doesn't change agency goals, is the intent. As I said, the comment period closes in December. We'll go through the comments and then we'll come up with a final rule. Once we're done with that final rule, we'll have to send that to the FAR Council. FAR Council will, come up with FAR changes. There's also going to have to be system changes to ESRS to actually implement this legislation. The next thing I want to talk about is the Women-Owned Small Business Sole Source Authority. This was in the NDAA of 2015. Basically, it puts the Women-Owned Small Business Program on the same field as HubZone and SDVO. It's not like 8A, where in 8A you have to go sole source under these certain thresholds, and you can do competition above. Under this authority, just like HubZone or Service-Disabled Veteran, you can only do a set-aside if you've done or you can only do sole source if you can't do a set-aside. As a CEO, you've done market research, you've identified one, but you haven't identified two. If you've identified two, then you have to do a competition. Now, it still has to be in the NAICS codes that we've designated as available for set-asides or sole source. We did a study of all the NAICS codes to determine what NAICS codes women-owned small businesses are underrepresented in. And that's available on our website. And so that still applies to this authority. And the price has to be below $4 million, estimated price, or $6.5 million for manufacturing supply contracts. And of course, as a CEO, you have to make sure that you believe you can make award at a fair and reasonable price. I give you the citation there. Now, this is a final rule. We did a proposed rule. This is final. Generally, a proposed rule, generally a final rule is effective 30 days afterwards. So it's effective October 14th. Now, this rule still has to go to the FAR Council, and they're working on that. They have to put it in the FAR, the authorities in the FAR Part 19. They also have to change FPDS to create a new category for women-owned small business sole source. So I expect this to actually be in the FAR and to be in FPDS sometime in November. The Section 825 of NDAA of 2015, in addition to giving us this sole source authority, it also directed us to conduct a new study of the industries where women-owned small businesses are underrepresented. and we need to do this by January of 2016. And so we are working on that. We're working with the Commerce Department to help us and analyze the most current data that we can get to establish whether the same NAICS codes will be in effect for this program, or will there be new ones, or will there be less. We should hopefully meet that January deadline. They also imposed on us a certification requirement. Right now we have a certification program for 8A, and we have it for HubZone. For small business, that's a self-certification program. For service-disabled veteran-owned small businesses, that's a self-certification program where you just represent you are what you claim to be, and that can be protested. The women-owned program is a kind of a hybrid. It is a self-certification program right now, but you have to upload ownership and control documentation to a repository, and under the rules as implemented, the CO is supposed to check those to make sure those documents are there. So it's kind of a hybrid system that we've been operating on since 2011, when this program really started. Well, under the NDAA of 2015, we're going to have a certification program. Now, we do have third-party certifiers right now, where you can, I guess, pay to be certified by these third-party certifiers, and we do have a relationship with them. But we didn't create that for purposes of being the certifier for everybody. So it's not mandatory right now. You can do it if you want, but it's not required under our current rules. As we move forward with this legislation, we have to figure out who's going to do it. Is it SBA? Are we going to have a hybrid system where there's SBA and third parties? Are there state agencies that already do this? Do other federal agencies already do this kind of certification? So there should be some rulemaking coming out soon from SBA, getting public comments on how we implement this particular piece of legislation. Right now, there are several FAR rules that are going on that are actually implementing SBA final rules and the Jobs Act of 2010. So I'm providing you some of the citations here. The comment periods have closed, so these should be coming out as final rules here in the next few months. I know they're working on subcontracting, they're working on consolidation bundling, they're working on multiple award contracting as well. And then the last thing I want to talk about is this advisory size decision rule that we were required to do. This is also from the National Defense Authorization Act, I believe, of 2013. And it basically tells us, they were frustrated because SBA will only do a size protest if there's apparent successful offeror and you have unsuccessful offeror. So it has to do with a real case, a real contract. We don't have the resources to just be giving opinions out about whether someone is or is not a small business. Well, Congress, I guess, was not happy with that, and so they directed us to create a system where a small business development center or a procurement technical advisory center can issue an advisory size decision, and then that will be sent to SBA's Office of General Counsel, who will then decide whether they agree with the opinion or whether they don't. And so the way we set up the process is, to get this advisory size decision, you have to do all the things you would have to do for a size decision from SBA. Submitting, you'd have to submit a form and submit all your ownership and control documents, everything needed to make a size decision. And then the PTAC or SBDC will submit that to SBA, and then we'll make a decision on whether we agree with it or not. And if we don't agree with it, then we can certainly do a formal size determination on our own, under our own authority. All right, so I've provided also my contact information there, and I think we may have some questions.
Okay. Thank you, Ken. It's always a pleasure to have you come and do a presentation for us. It's always informative. So at this point, we're going to take questions, and I'm going to have Ken do some answering. Do a first question.
We're pulling it up right now.
Okay, while we're waiting, Ken, I have a question.
Okay.
How do you define an excessive joint venture?
That is a good question, and a lot of times we leave our rules open because we want to do each size decision on a case-by-case basis. So it's hard to write rules that apply to everybody. So what we want to do is we want to be able to take a look at each contract, each relationship, to make sure that the firms are actually not affiliated. So there's so many factors that go into that, family ownership and control, sharing of resources, things like that. So what we will do is we'll have OHA decisions, and those OHA decisions will say this is excessive and this is not, and then you can kind of try to figure out as you go along, are you in this boat or are you in that boat? And that's kind of the best I can do right now.
Okay, thank you. The first question I have, does the CO have to issue a WOSB competitive set-aside RFP first, or can they use their market research to determine there is only one WOSB available?
That's a good question, and my answer is, if you've done your market research and you know that there's only one that you believe that can do it, I think you can do a direct sole source award at that point. I don't think as a government we want people wasting lots of time and effort doing a solicitation that they don't think is going to be reasonably be responded to, and then having to cancel that and then go back out. So I think in the government we want to save as much time as possible. As long as you've done your research and you're confident that you're right, you can do a direct sole source award.
Thank you. The next question, will you please confirm that the LOS requirement only applies to small business set-aside over the SAT, the SAT?
Yeah, and this has been in the FAR since the 80s. And it's based on the way the statute is written. The limitations on subcontract are in the Small Business Act, and they refer to sections like Section 8A and the Hub Zone section and the Service Disabled Veteran section, and the authority for set-asides above 150, which is section 15A. They do not refer to Section 15J. 15J is the authority for small business set-asides below 150. So look in the bottom of Part 19.5. It'll tell you when to insert 52-219-14, which is the limitation on subcontracting. And what it says there is, insert this clause into solicitations that are set aside for small businesses above 150. And it also says for 8A. So it does not, so basically it's never said that you should insert that into a set aside below 150.
Okay, thank you. Okay, next question. LOS and NMRs do apply to 8A and Hub Zone set-asides. Why is this different for small businesses set-aside, since the 8A or Hub Zone firms have first to be small?
Yeah, and that's a good question, and that's kind of what we're trying to do here, is to move away from this kind of different rules. But the reason we have these different rules is it's based on the way the legislation was written. If Congress says the prime must do this limitations, then we would apply those rules to the prime. In the Hub Zone or SDVO context, they did not say that, and so in those cases we said, well, we want, as long as the sub is the same type of entity, we want the sub to be able to count towards that limitations, because that helps small businesses team together and do bigger contracts. And so that's based on the way the legislation was written, but they've changed it under this NDAA, so that will be changing. In addition to that, Hub Zone, when it was created in the 90s, they created different rules, tougher rules. They do not allow right now non-manufacturers to qualify above $250 or $25,000. So basically you can't do non-manufacturer waivers for the Hub Zone program right now. We're proposing to change that to allow Hub Zones to also be like other non-manufacturers and to get waivers. And so that's part of what we're trying to do here, is to make all the rules for every program similar to the extent we can.
Okay, thank you. Next question. How motivated is the SBA in helping SBE obtain a contract either as a prime or subcontracting once they are 8A certified?
Well, I think we have a lot of resources. When you're certified as an 8A, you do have a BOS there in the district office, and you have a district director there and a deputy district director, and you have people there to support you. But in the end, getting in the program does not get you anything. I mean, there are many firms in the 8A program that go through that program without getting any contracts. So it's a license to hunt, basically. You have a lot of benefits when you get in the program. There's technical assistance, there's business development assistance, you have the Protégé opportunities, but it's still, and you have this sole source thing that you can market, where you can get direct sole source awards without question below those threshold amounts. But once you're in the program, it's still kind of on you to develop some business.
Good. Next question. What is a COC?
Yeah, it's a term of art. You know, at SBA, it's known as a certificate of competency, and what that means is when a contracting officer finds a small business to be non-responsible under Small Business Act legislation and under our rules, the CO has to refer that firm to SBA. SBA will take a look at that firm to see if they're responsible. If we believe that they're actually responsible, we can issue a certificate of competency, and that basically says that you cannot deny that firm award on responsibility grounds.
Okay, thank you. Next question. The contact info for the presenter was only up for a few minutes. Can you please provide contact info for the presenter?
Yeah, I think they'll probably provide the PowerPoint as part, they can put it on their website or something like that, so you'll have that.
Thank you. Thank you. And yes, we will. And we'll provide that at the end of the we'll provide all of the presentations. Once you finish this, watching this presentation, you will be able to get a copy of this presentation and your CEU, and your training certificate by doing the survey, completing the survey. Okay? Next question. Is the federal government meeting its yearly SBE set-aside goal percentage? I believe of 40 to 45%.
I'm not familiar with the term SBE. As far as small businesses, there's a 23% goal, and we've met that the last 2 years. We met it in 13. In 14, we did 24.99%. We've also, in many years, we've met SDB goals. We've met the SDVO goal last year. Women-owned small businesses, we're trending up, but it's a 5% goal, and we've been around 4%, so we're making progress. Maybe this sole source authority will help towards meeting that. And then HubZone is the goal we've had the hardest time meeting. I don't know that we've ever met it as an agency. The goal is 3%, and we've been, not getting there, and there's a lot of reasons for that. Hopefully, when we change some of these rules to make the HubZone program like other programs, that'll kind of enable HubZone firms to do better and to start getting those goals higher.
That's good news, Ken. Very good. Another question, I'm confused about the protests regarding the size of the 8A companies. Their status is verified before we engage with them, isn't it?
That's a good question, and I'll explain it like this. We've always said that in a competitive set-aside for 8A, you can do a size protest just like any other procurement. And the reason we have that is because we don't necessarily know everything. Yeah, you're right. They've been certified, they've been allowed in the program, but what if a competitor comes up with information that they didn't disclose to us, that they're really owned by someone else or they're relying on someone else? That's the whole point of a protest process. Just because you're protested doesn't mean you're ineligible. We deny protests all the time, but you still have to, defend yourself. If it's not credible information, SBA may dismiss the size protest. But if it's a credible allegation, we're going to look into it because we want to make sure for our programs that the actual businesses are small.
Good. Thank you. Okay, the next question is, does the CO have to issue women-owned small business competitive set-aside RFPs first, or can they use their market research to determine if there's only one WOSB available?
Yeah, we did that one earlier. In my opinion, once you've done your market research and you know that there are one but not two, then you can do a sole source award.
Good. Will you please confirm that the LOS requirement only applies to small business set-asides over the SAT?
Yeah, I think we did that one earlier, too.
Oh, we did. I'm sorry.
Yeah. Take a look at the end of 19.5. It directs you when to put 52.219.14 into the solicitation, and it specifically says not if it's below 150.
Okay. Sorry about that, Ken. Is there a GSA schedule type tool for finding qualified small businesses?
Well, I hope there is. I mean, we call it the dynamic small business search. We've had a database at SBA where we want firms to go in and after they register in SAM, because you have to be in SAM, you have to do the ORCA representations and all those things. But once you're done with that, SAM is about awarding contracts. DSBS allows you to enter information like contracts you've performed, keywords, contact information. There's a lot of, and we are working on making DSBS better, but there's a lot of information you can get there. And so CEOs, I hope, ones that I know, they do use DSBS to do market research to find You can search for women-owned small businesses or hub zones. You can search based on location. You can search on all kinds of criteria there, and that's where we direct our CEOs to go if they want to do market research.
Good. Let me go back, Ken. How is SBA coming along with increasing the number of hub zone firms?
Well, I think we're doing a lot of outreach. The program is doing things, destination hub. They're going out to areas that are hub zones to let people know in those areas that they're in a hub zone and that the employees in that area might be eligible to work for them, and then they qualify as a hub zone. Hub zone's difficult because things change that are out of your control. You may be in a hub zone one day, but because of the way we establish hub zones, which is based on all this other economic data, tomorrow it may not be a hub zone. And then also your employees, you might be a hub.
May I have your attention,
Oh, we have a
please?
fire or something.
May I have your
You might be a hub
attention,
zone,
please?
but then you're
We
not.
have an
Your
emergency
employees
in
may
the
leave.
building. All occupants are instructed to move or remain in their workplace. Please stand by for further instructions.
All right.
So,
Got 'em.
sorry for the interruption. Okay. Did you finish, Ken?
I believe so. I mean, basically, hub zones, it's very difficult, and so we're doing everything we can.
May I have your attention, please? May I have your attention, please? We have an emergency.
I'm sorry, certain things are beyond our control here at HHS. Okay, next question. Okay. HHS will be partnering with SBA on a destination hub zone.
Good. Good.
So we're looking forward to the participation, to the
Good.
involvement,
Good.
okay? Okay, I have another question here, Ken. Someone had, I guess before you had asked, what does SBE mean? And so someone came back and they responded by saying small business enterprise. So the question is, once the goals are met, can we use another vendor without a waiver?
No. I mean, basically the rule is, the starting point of all market research is the rule of two. Okay, so you do market research. If you think, reasonably that two small businesses can do the work at a fair and reasonable price, this FAR says you shall set it aside. So that's the starting point. Now our rules do say, yeah, you should look first to 8A, Hub Zone, and SDVO, or women-owned. But the bottom line is we think that even if you're meeting your goals, it says shall, you have to keep doing it. Because remember, as an agency, you're helping us. Even if HHS is meeting their goals, if they do more small business work, that helps the whole government.
Okay. I'm sorry, Ken.
Well, this is different.
This is very different. Okay. Okay, the next question is, thanks for this, okay, okay, so. Okay, just to be clear on the NMR, can a large business sell a small business product with a waiver?
No, I mean, the whole point of the NMR is you're still doing, when we do it, you're doing a small business set aside. That means the offeror needs to be a small business, and the small business rules on a non-manufacturer are you have to be below 500 employees, you have to take possession of it, and so forth. We have rules on that. If we had issued a waiver, though, you're allowed to sell the product of any size business. That's the difference. Otherwise, you still can qualify as a non-manufacturer, but you have to sell the product of a small business. If we have issued a waiver, then they can sell the product of any size business. Still has to be a small business, though.
Thank you. Are there any other questions out there? Okay. If not, then I would like to just thank Ken for being our presenter today. This was very informative. And on behalf of Teresa Lewis, the WOSB Director, we just want to thank you, as always, for coming here to do this presentation.
Anytime. Thank you very much.